Hello, all. Welcome to everyone. I believe you have been going through my slides religiously and trying to understand the new legal concepts. In our last session, we had gone through the brief introduction of a contract and the essentials of a valid contract as per Section 10 of the Indian Contract Act 1872. Today we will begin with our first formality which is given under section 10 of the Indian Contract Act, and that is a valid offer and a valid acceptance. Now this forms to be the first topic in your first unit as per your curriculum. In simple words, an agreement is said to be a valid agreement only if it consists of a valid offer and a valid acceptance. That means agreement is equal to offer plus acceptance. Section 2, Clause A of the Indian Contract Act 1872 defines offer as when one person signifies to another his willingness to do or abstain from doing anything with a view to obtain the assent of the other to such an act or subsistence, he is said to make a proposal. Now, the word proposal in Indian law is equivalent to the word offer as per the English laws. So, whenever we are using the word proposal, it is equivalent to the word offer throughout the Indian Contract Act. This being the definition of offer, Section 2, Clause B of the Indian Contract Act defines acceptance as when a person to whom the proposal is made signifies his assent thereto, it is an acceptance of the offer or proposal. The person who makes the offer is known as an offerer or proposer, and the person to whom the offer is made is known as an offeree or proposee. When an offer is made by the offerer to the offeree, it gives a right to the offeree to accept that particular offer or not. If the offeree accepts that offer, the offeree gets turned into an acceptor. So, when and only when the acceptance is given by the offeree to the offerer, the binding legal obligation under the Indian Contract Act begins, and thereby only and only when the offeree accepts the offer, an acceptance is said to be conveyed to the offerer. We will begin with certain essentials of valid offer and valid acceptance. The first one being the essentials of valid offer. Now, if you see the entire definition which is given under section 2A, it comprises of two important essential elements. First, that there should be an expression of willingness by the offerer to do or abstain from doing something, and secondly, that such expression should be made with a view to obtaining assent from that other person. These two being the most important criteria, there are simple words which are given in the entire definition, which we will try and look at it one by one. Now, the first important essential of a valid offer is that it must be capable of creating legal relation. That means it must be capable of creating any legal obligation. Understand, on our day-to-day basis, we make a lot of offers to different people. For example, your mother might be offering you food, or your parents might be offering you to go to a shop by giving you certain money in your hand. You might be offering your friend to come home for dinner. All these are also considered to be offers, valid offers, but they cannot be brought under the Indian Contract Act or under the legal diaspora for a simple reason: they are not capable of creating any legal relationship. When we see at the definition of offer, the first wordings which have been mentioned is that signifies to another his willingness to do or abstain from doing something. That willingness should not be a casual willingness, but that willingness should be with an intention to create a legal relationship between the parties. And only when a legal relationship is created between the parties, it will have been said to become a valid offer. For example, there is a landmark judgment of Balfour versus Balfour, This judgment came into picture wherein the court tried to understand that when an offer and acceptance is done between husband and wife as a routine matter, will it create any legal obligation or a contract binding upon each other or not? In Balfour versus Balfour, the courts held accordingly that when a husband or wife on daily basis create certain agreement between themselves, all these agreements cannot be said to be converted into a valid binding contract, because agreements between husband and wife or parents and children or friends all together on daily basis as a part of a routine cannot be said to be capable of creating legal relationship. And that is why an offer to become a valid offer under Indian Contract Act must be capable of creating a legal relationship. The second important essential of a valid offer is that the terms of the offer must be certain, they must be definite, and they must not be vague. Now the words here which I have used are that it must be certain. That means there should be a certainty of performance of that particular offer. When I am trying to make an offer, for example, I am trying to make an offer to my friend to sell my car for 10,000 rupees, I should make a specific offer saying that I want to sell my car for 10,000 rupees. But if I am making an offer saying that I want to sell my car maybe for 10,000 rupees or for 8,000 or for 12,000 rupees, this offer cannot be considered to be a certain offer or a definite offer, because it is vague. For a simple reason, the amount of consideration itself is something which I am not offering to the offeree, and thereby such offers cannot be considered to be valid offers. The terms of the offer should be certain enough, which should be understood by the offeree. If they are ambiguous or if they are uncertain, it will not be considered to be a valid offer. The third essential factor is that the offer may be specific or it may be also general offer. Now, this particular distinction between a specific offer or a general offer was for the first time made by the courts in another landmark judgment, which is considered as a Carlyle versus Carbolic Smoke Ball Company Limited judgment. Now, in this case, what had happened was that Carbolic Smoke Ball Company Limited was a pharmaceutical company, means a medicine making company. During those times, the disease of influenza was very common and it was widespread. Now, this particular pharmaceutical company for the first time created, or rather invented, a medicine for curing, or rather as a vaccination for influenza. And this company made an advertisement saying that whosoever consumes our carbolic ball, that is, whosoever consumes our medicine, will never ever contract influenza. Now, Mrs. Carlyle, being one of such citizen, purchased the medicine from the company, and according to the directions given by the company, Mrs. Carlyle consumed that particular medicine. But even after consuming the medicine, she contracted influenza. Now, as per the advertisement which was given by Carbolic Smokeball Company Limited, saying that if after consuming our medicine, if anybody contracts influenza, we will give them a reward of £100. Now, this particular advertisement, which was read by Mrs. Carlyle even before consuming the medicine, after she contracted influenza, she went to the company saying that I consumed your medicine as per your directions, and even after consuming your medicine, I contracted influenza. Now, you will have to pay me £100 as per your advertisement. Now, in this case, Carbolic Smokeball Company Limited said that we did not make any specific offer to Mrs. Carlyle, and that is why Mrs. Carlyle cannot accept our offer. Meaning that if we have not made any offer to Mrs. Carlyle, how can she give an acceptance to it, and thereby there cannot be any binding legal agreement or a contract between us. Now, this particular dispute went to the court, wherein Mrs. Carlyle filed the case in the court saying that as the company had made an advertisement, this advertisement was read by me, it was accepted by me, I consumed their medicine, and even after that, now I have contracted contracted influenza, I am eligible to claim the £100 reward. Court in this case agreed with Mrs. Carlyle's dispute, saying that when any offer is made as an advertisement to the public at large and not to any specific person, it will still be considered to be a valid offer, and such offers are said to be general offers. Thereby coming to the conclusion, when an offer is made to a specific person or to a specific group of people after identifying them, it is considered to be a specific offer. But when an advertisement or when any offer is made to the general public at large, it will be considered to be a general offer. And in this case, for the first time, the distinction between a specific and a general offer was made. The next essential condition for a valid offer is that the offer can be express offer or it might be an implied offer. Now, in this case, the express offer means that the offer must be expressly stated to the other party, that means to the offeree. For example, when I tell my friend that I want to sell my bicycle for 1000 rupees, it is considered to be an express offer. But when I tell my friend that nothing has to be said, or rather, giving another example, let's say I am not keeping well, I am suffering from any disease. The minute I go to the doctor for a treatment, he conducts, this conduct of mine will be considered to be an implied offer. In case the treatment is given by the doctor, the offerer, that means me, has to pay the doctor's fee. So the fact that I went to the doctor for the treatment, that means I have offered it. The minute the doctor treats me, he accepts my offer, and I have to pay the essential doctor fees. Such type of offer is considered to be an implied offer. The next essential condition is that the offer must be communicated to the other party. To explain this point, I have another landmark judgment which was released by the Allahabad High Court in 1913. So 1913 being another old example for this point, but this landmark judgment still stands good when we are trying to consider essentials of valid offer. This case is Lalman Shukla versus Gauri Dutt. In this case, Mrs. Gauri Dutt, the son, went missing and nobody could find him anywhere. They tried to contact his friends, relatives, neighbors, but he could not be found anywhere. And that is why Mrs. Gauri Dutt announced a reward of 1001 rupees to whosoever who found her missing son. Now, Lalman Shukla was Gauri Dutt's servant, and he also went searching for the boy, obviously, but he did not know about this particular reward which was declared. So, Lalman Shukla went ahead for searching this boy. In the meantime, Gauri Dutt, who had announced this particular reward of 1001 rupees, he did not know about Lalman Shukla searching for the boy. Lalman Shukla, without the knowledge of this announcement of reward, searched for the boy, found the boy, and brought him home. Subsequently, later on, Lalman Shukla came to know of this particular reward, and he went to Gauri Dutt and claimed the reward, saying that I have brought the boy home, you need to give me this reward which you had announced. Now, in this case, Gauri Dutt said that I never made an offer to you, meaning that if you did not even know about this offer, how can you go ahead and even accept the offer, because you did not even know about this reward which I had announced. Court rightly held in this court that for an offer to become a valid offer, it must be communicated. Now, the word communication, which we also take it in the normal parlance, means that the other person should understand you in the same manner you wanted to put for your point, and then only we said that the communication is complete. But in this case, the servant, that is Lalman Shukla, did not even know about that particular reward point. How can he go ahead and accept that particular offer? So the court denied the reward to be granted to Lalman Shukla, saying that if the person did not even know about the offer, there cannot be any binding agreement, because there is no point of giving him the reward when he had not accepted the reward, as he had no particular offer intimated. information. So this was one of the point which the court held as a very important point. Another important point which is necessary for making an offer a valid offer is that it must be made to obtain the assent of the other party. Now, the word assent here means approval or conversance, saying that yes, now I am agreeing to this particular point. That is known as assent, approval for it. If the person is making an offer but it is not made with an intention to obtain the approval of the other party, it will not be considered to be a valid offer. The expression willingness is important here, because if the offer which is made to the other party, it must be made to obtain the assent of the other party on that proposed act. If the intention of the person putting the proposal is just to express his opinion, his idea, his viewpoint, but there is no intention of getting approval for it, then it will not be considered to be a valid offer. Another important point is that an offer may be conditional offer. Now, this is one word, conditional, which is important for a simple reason. On day-to-day basis, we find that n number of offers are made, especially the commercial offers which are made, wherein a condition is put in that offer itself, saying that if the other party wants to accept the offer, the condition also must be fulfilled either before the acceptance or after the acceptance, meaning that condition, fulfillment of that condition is a prerequisite for acceptance of the offer. So the offer which has a condition in it is considered to be a conditional offer. So if the condition is not accepted, the offer comes to an end. For example, a promise to sell the house, if some advance payment is made, is a conditional offer. If the advance payment is not made, the offer comes to an end. There cannot be a situation wherein a person says that I am ready to accept the offer, but I am not ready to accept the condition. Such offers cannot be considered to be valid offers, because if acceptance has to be given, it has to be given to both the offer and the condition present in that offer, and thereby an offer may be a conditional offer as well. The next important point is in again which is put forth after a landmark judgment which even stands today. This is a very old judgment. It is 1893 judgment. It is the UK court's judgment known as Harvey versus Facey. In this particular case, a very important point was laid down to distinguish an offer from an invitation to offer. Now, in this case, what had happened was that A had sent a telegram to B, the parties' names A and B, I have tried to simplify them, wherein A sent a telegram to B saying that, will you sell me a hall pen, bumper hall pen? That was a typical pen which was to be sold. Telegraph the lowest cash price to me. Now, B telegraphed in reply that the lowest price for bumper hall pen is £900. A then telegraphed saying that, okay, we agree to buy the bumper hall pen for £900. Please send us the pen. Now, in this case, B did not give any answer to this telegram, and it was held that there was no contract as the second telegram. That means the telegram saying that we agree to purchase the bumper hall pen for £900. This particular telegram was not considered to be an offer, but it was considered to be an invitation to offer. Now, the words offer and invitation to offer are very much distinguished, which you will also come across on your day-to-day basis. For example, tomorrow if you go to a mall for some shopping purposes, example, you will see there are so many things on display. For example, if you go to a boutique, you see a mannequin on which beautiful clothes are put up. You want to purchase one of the let's say a dress which is put up on the mannequin. You enter the shop and you say to the shopkeeper that I want that dress which is put up on that mannequin. Just because you are asking the price of that dress and you are giving in willingness to purchase that particular dress, it is not considered to be an offer, for a simple reason. If the shopkeeper feels that he does not want to sell you that dress, let's say it is a single piece which is left, or it is booked, that dress is booked by somebody else by paying advance payment, and if the shopkeeper says that no, we cannot sell you this dress, you cannot file a case against the shopkeeper saying that I had made an offer, you must accept it, or there is an agreement. Or you cannot go ahead to the shopkeeper and say that the fact that you had put the dress on that mannequin means that you had made an offer to me as a general offer. Maybe the fact that I entered your shop, I am ready to pay the amount of money, means I have accepted your offer. This is something which does not work under the Indian Contract Act, and as rightly held under Harvey versus Facey, the minute the shopkeeper puts a dress upon the mannequin, the shopkeeper is not giving you an offer, but the shopkeeper is giving you an invitation to offer. That means he is inviting offer from the public at large. You go to the shopkeeper, you ask the shopkeeper that yes, I'm ready to purchase this dress, what is the cost of that dress. It means that you are making an offer to the shopkeeper. Now the ball is in the court of the shopkeeper whether he wants to accept your offer or not. If he rejects it, that means there cannot be a valid binding agreement. But if he accepts your offer, thereby you go ahead to the stage of a valid agreement. So whenever you go for any shopping, or you go for any shopping to the, let's say, to any particular mall or to any shop, you travel in the bus, all these are considered to be invitation to offers, and they are not offers. Another important criteria for a valid offer is that it should not contain a term the non compliance of which would amount to acceptance. Understand, whenever we are talking about offer and acceptance, it is the intention of the parties or the willingness of the parties which plays a very important role. Tomorrow, if I make a condition in my offer saying that if you do not accept my offer within a period of 10 days, it will be implied that you have accepted the offer, then such terms in the contract or in the agreement will be considered to be invalid. Let's say I make an offer to a person saying that if you don't intimate me your acceptance within 5 days, I will assume that you have accepted my offer and there is a binding legal obligation. Court says nothing doing. This cannot be any condition in your offer. If a person does not comply with any particular acceptance related terms, you cannot make the person do it compulsorily, because ultimately offer and acceptance is all about willingness of the parties. There cannot be any term in your offer saying that the non compliance of that will amount to acceptance. This is what the courts have been considering it. And the last important essential factor for a valid offer is that it may be revoked, but only before acceptance is given to that offer. When I make any offer to a person, I get a right to revoke it, change that offer, or to take back that offer only and only up to till the time the offeree does not accept that offer. Let's say I make an offer today and tomorrow I feel that no, I don't want to sell my, let's say I don't want to sell my bike to a person, then I can revoke it. But if I make an offer today and in the evening the offeree gives me his acceptance, then tomorrow I cannot call him and say that no, I am revoking my offer, because the minute the offeree accepts your offer of purchasing the bike, there is a binding agreement between both the parties, and thereby an offer can be revoked only and only up to the acceptance for that offer is not given. Otherwise, there is bindingness on the offerer once the acceptance is given to the offerer. Now these are the important conditions when you talk about the valid offer. In our next session we will go through the essentials of valid acceptance.